And President Bola Tinubu has asked the Senate to consider and approve a bill seeking to amend the Court of Appeal Act to increase the number of justices from 70 to 110. The request was conveyed in a letter addressed to the President of the Senate, Godswill Akpabio, and read during plenary on Tuesday. The proposed amendment is part of ongoing judicial reforms aimed at strengthening the appellate justice system and improving service delivery. The bill seeks to enhance the court's institutional capacity by addressing rising caseloads and operational pressures across divisions. It also proposes a review of provisions governing the structure and seniority of justices, including the Office of the President of the Court of Appeal. In addition, the legislation introduces measures to modernize appellate proceedings through increased use of technology. Now, to discuss this, we're joined by legal practitioner Deji Ajare. Deji, good afternoon, and thank you for joining us. What constitutional or statutory gaps can you tell us that's being proposed in this amendment to the Court of Appeal Act seeking to address?
Yeah, thank you very much for having me. The president's intention is clearly to reduce the backlog of cases, both at the Federal High Court and at the Court of Appeal, and of course to reduce the delay in justice delivery in Nigeria, something that is, of course, a major source of concern to every person, every actor in the judicial sector. And while, of course, it's commendable that, the president is seeking for ways to clear this. One thing that I can say for certain, and it's okay, it is in fact proper, but it is not enough to solve the problem of judicial delays and backlog of cases. Because there are so many other factors that are definitely involved. We must start emphasizing merit in the appointment of judges. Merit in terms of the capabilities, in terms of the intellectual capabilities of the judges. You'll be very surprised. This is an issue. And beyond that, merit in terms of the abilities of the judges to actually be in charge and control of their courtrooms. So many judges do not know how to take charge of their courts, and which inadvertently, leaves room for lawyers to take advantage of these gaps to delay cases, especially in criminal cases, something that should ordinarily be avoided. Now, you will agree with me, when a judge is, for instance, a judge at the Federal High Court or at the State High Court is underperforming, quite naturally, you would not expect such a person to be elevated to the Court of Appeal. But this is what we have. We have judges who are clearly not performing to their optimal capacity, but you see them elevated, and that's a problem. And besides that, there is also the issue of administrative functions that are usually assigned to lawyers. We must also go back to considering, ceding administrative functions to persons specifically trained for that purpose, so that judges, you go to court a lot of times and you find the court is not sitting. Why? Because the judge is attending a meeting on behalf of the chief judge or is attending to an issue. These are issues that necessarily delay the course of justice, and we must go beyond just appointing more judges. We must go into the nitty-gritty to really address all those other issues that are affecting the sector.
Right. So, Deji, basically what you're saying is, instead of increasing the justice from 70 to 110, they should figure out who the justices who are not capable and take them out. So that's one that I want you to respond to. And if at all this increase happen, does it require only an amendment to the Court of Appeal, or are there going to be broader institutional implications under the 1999 Constitution?
Well, first, I am not saying jettisoning the idea of increasing the number of judges. It's okay to do so, at least to reduce the dockets of the judges. But what I am saying is that it is not enough to address the issue of judicial capacity. there is a lot more that needs to be done if we are going to achieve the result that we desire. Appointing more judges will not automatically solve the problems. But one, if we are going to appoint judges, we should ensure that the process follows the procedure in the NJC's guidelines. We must follow it. That's one. Secondly, in appointing and in elevating judges, we must emphasize merit. We must emphasize merit rather than the current system where persons are rewarded based on their family relations or based on their political connections. That must not be allowed anymore. That's a major problem.
Nice.
And so, yes, we could appoint more judges, but we should ensure that we allow merit to reign in the appointments and elevation of judges. There must be other things that will be done to reduce this procedural bottleneck. And I have also suggested that, yes, we should remove administrative functions from judges' tables. Now, as to your question as to whether the amendment of the Court of Appeal Act and the Federal High Court Act is all that needs to be done, I assure you, no, there's much more that needs to be done. Because first, when judges are appointed, when the law is amended to increase number of judges, it does not automatically mean that the next day all those judges are appointed. You would recall that for several years at the Court of Appeal, despite the fact that there was a provision for 21 judges, all those seats were not filled. All those seats were not filled until 2023. So first, after that, after the amendment of the law, then there must be a recruitment process for the judges. And it's not just recruiting that is all that needs to be done. You now need to talk about welfare of those judges. So first, you also now need to go and increase the number of courtrooms. As at now, courtrooms they're in deficit. So they will need to increase the physical structures that are necessary for the courts to sit. Secondly, still talking about their welfare. You must start looking at providing vehicles, providing staff, and so on and so forth. And now, when you're talking about the Federal High Court and Court of Appeal, remember that these are courts that have their divisions across the country. So you must start planning transfers, because transfer of judges is also a major problem, a major cause of delays in justice system. Because anytime a judge is transferred, all his cases that are part-head need to start de novo. They need to start afresh all over again. So then there's need to start planning transfer and elevation of judges in such a way that it will not impact on cases they are already handling, or at least it will limit the impact to the barest minimum. And of course, that means increased funding for the courts. So while the president may think, oh, it is beautiful, it is sweet to increase the number of judges, and I support that, but the president must also start thinking that this means increased funding for the judiciary, because when that does not happen, then you already create a problem. And then that goes to independence of the judiciary, which is also a problem for all of us in the country, because when the judiciary is not independent or not seen to be independent, then it creates a problem of public trust or distrust, as the case may be.
Well, Deji, I almost wanted to ask you another question, but I'm sure we'll follow up this conversation, because you have mentioned merit a couple of times, and I would also like to see or ask you to share with us what was the process in choosing these justices. But we were out of time, but we'll keep following up the situation and see how it goes. Thank you, Deji, for joining us.